So welcome everybody to this webinar. I am so excited to have Brian Schwartz here to have this really great and rich conversation about reopening during this time of COVID and what kind of laws are in play. It's the kind of conversation I could never have with you with my expertise and background. So I feel really honored that Brian is here to share with us today. And I'm going to share my screen and I'm going to just turn it over to Brian to say a little bit about himself and his background.
Great. Well, Elizabeth, thank you again for inviting me to speak to the group. I really appreciate it. And it is kind of a landmark day for me because I wore a collared shirt. And since March 10th, which was the last in-person meeting I've had with a client, I've worn a collared shirt. This is only the fourth time. So you guys should be honored. You didn't get the sport coat treatment, but you did get the collared shirt treatment. So it's great to be here. And let me just describe who I am and what I do. I'm a management side employment lawyer. So I represent businesses only in all their employee relations matters. And there's kind of two tracks to what I do. One is all the day-to-day counseling regarding disciplinary decisions, or unfortunately we have to make decisions to terminate employment sometimes, or how to handle requests for leave under like the FMLA, or if an employee has a disability, how do we accommodate their disability? So that's what I spend most of my time on. It's just advising clients with respect to employee relations matters. And kind of the other part of what I do, which the clients never enjoy engaging me for, is litigation. Unfortunately, try as we might, lawsuits happen. But the goal is, if we have good policies in place, they're clear, they're unambiguous, and they're fair, it cuts down on the likelihood we'll get sued. Or if we get sued, we may be able to effectuate a quicker settlement by telling the opposing lawyer, hey, look, I don't think there's cases that strong. Here's why. We do things the right way. And if we can't get a case settled, then we litigate. And when we litigate, we have one goal and one goal only: win. Okay. But the idea is to never be in the position before we're waiting for a jury to return a verdict, because that is the most nerve-wracking experience anyone could ever experience. So that's what I do. And today I'm prepared to talk about the COVID effect on business operations, because I've dealt with that almost exclusively since March. But this, as Elizabeth said, this could go in different directions. If you have any questions at any time, interrupt me. I love to be interrupted. I love when things turn into a town hall format, and maybe I can mention something that's on top of my mind, and then you could share an experience that you have, and then someone else weighs in, hey, wait, I experienced the same thing. Questions beget more questions, and interesting topics kind of beget other interesting topics. So that's ideal. And as I always say, and I said this to Elizabeth on the phone the other day, if I'm talking start to finish uninterrupted, I know you're going to get bored of me. I'm going to get bored of me. Okay. So with that said, I want to talk about kind of the now that businesses are opening. Let's talk about the COVID effect on businesses. Let me ask this question, since we have a small group. I mean, what are you guys are nonprofits. I mean, do you have employees? I mean, I don't know if anyone wants to weigh in individually, or Elizabeth, you want to just summarize? I mean, what kind of group do we have here?
I'll let people speak for themselves. Jump in back, guys.
This is Michelle. We have 8 employees.
Okay. 8 employees. And how about Jackie, Melissa, and Jeffrey?
I'm Jackie, and we had 36 employees before COVID hit. They're dropping as we're approaching. I'm a preschool, so we're dropping teachers as it approaches, but I still have the core of them. I've just dropped maybe 5.
Okay.
And I'm Melissa. We have 4 employees. We're a counseling ministry, so we get clients from all over the United States that come for 5 days intensive.
Got it. And Jeffrey?
Well, I'm a partner firm. We tend not to sue each other. So, we don't have those kinds of issues. But I do work with some clients, some of which are fairly complicated. And there are some do's and don'ts in the legal arenas and the compliance arenas that I'm always having to be careful about. So I'm curious to hear more.
Got it. Okay. Well, welcome. So I think the first topic area to cover with respect to how COVID impacts the workplace is planning and communication. Let's be real. Our employees are afraid. And guess what? I'm afraid too, okay? And I imagine that there's people on this, everyone else on this call has some level of fear and apprehension as well. So what we want to do is it's really important that we design a good plan of communication. And I think as a starting point, every business needs to designate the internal team or an assigned point person in charge of dealing with COVID-19 operating decisions. If we have too many cooks in the kitchen, the message could be distorted, it could be just unclear, or it may not be uniform, okay? It's better to be consistent and have agreement on one policy as to how we're going to handle certain issues than just everyone fending for themselves. Now, keep in mind, although every good employer needs to be consistent, and I always preach that, every good employer also needs to be nimble as well. So that's sort of a contradiction I'm leading with. I realize that, but it's not always one size fits all. If you do have an internal team or a point person to disseminate one clear message, it's going to allay employees' anxiety and foster direct dialogue relating to COVID. That's really important because, again, employees are anxious, and I'm anxious too about COVID. In situations where we have high absenteeism, and that could occur through employees who are furloughed, we're running with a leaner staff, or if we have an uptick in cases in our organization and people are out sick or they're quarantining because they've been exposed to someone. In advance, I think you should plan. How are you going to operate if we're not at full strength? Okay, because we don't, it's going to be bad enough to not be at full strength, but we don't want that to be paralyzing, okay, because we still need to operate. And I think it's important from a planning standpoint and a strategy point of view to create and test emergency communication channels. Now, I mean, that sounds way more official than it needs to be. I mean, it could just be, do you have like a phone tree or a text or a tech group text exchange? I mean, because if people are not on site together, I think you got to make sure you have a good process to disseminate mass communications, and it could be text, it could be email, but it sounds trivial, but it's something that you should consider. If you have supervisors, I think they need to be trained and alerted to the non-discriminatory application of policies related to COVID. And I'm going to explain more about how to do that when we get into the actual laws impacting the workplace in COVID. And I think it's important that your policies should be reduced to writing. Develop written communications to managers and supervisors and employees to convey key messages about operations, procedures, protocols, etc. Everyone needs to be on the same page about what we intend to do and what we expect of people. So, going about it, kind of willy-nilly without really thinking in advance, that's usually a recipe for disaster. Okay, so we want to have some planning. Any questions about like planning or procedures, protocols, before I move on to the laws?
I just wanted to say I thought it was really interesting as I saw what you were preparing. I thought, okay, yeah, you're going to come and you're going to talk to us about laws. And just that you even started with this idea of our own planning and communication, it to me makes me think that a lot of pre-planning will help us to avoid problems with laws later. That was kind of the message that I got from that. And I'd love, confirmation on that, or maybe, say a little bit more on that.
Yeah, so you're spot on correct, Elizabeth. That was the intent of my message. I view my job as an employment lawyer for businesses in a very, very holistic way. First of all, we must always comply with the law. It's as simple as that, okay? But what we want to do is, a lot of times the law is fairly limited. In other words, yeah, we'll protect an employee in a certain way, and we've complied with the law. We couldn't get in trouble for that. But it still kind of leaves the employee hanging a little bit. And I don't like that, okay? Because even though my friends who represent plaintiffs, they always say I'm a dark side and all that. I don't buy into that at all. I like to implement good change for businesses where they're fair to their people. And because if we're being real, the business owner who has his 3 homes and their Maseratis and their Range Rovers and their boats and they go on these cool vacations, they deserve all that because they invested their capital. They put a lot of blood, sweat, and tears into building the company. But the company doesn't stand without its foundation, and the foundation are the employees, okay? So planning is important because it's gonna ensure not just that we comply with the law, but it's gonna mean that we're fair to our people. I am all about fostering good employee relations. Now, in this group, we don't have to worry about unionizing, okay? But for my manufacturing clients, I always say, if you don't have good employee relations and fair practices, you are asking for a union, okay? And I don't want to make this about unions, but for a management side standpoint, a union is taking on a business partner that A, you don't know, and B, you never wanted. So that's why we look at things holistically. How are we helping our people? And planning in advance prevents legal issues. I'm all about prevention. The best way to deal with me is just to have a casual conversation. Hey, here's the scenario, Brian. What do you think? If you're calling me and say, hey, Brian, I was referred to you and we have a lawsuit because it says we didn't pay overtime. And I say, well, did you pay overtime? No, we didn't. I'm going to say, okay, here's my great advice to you. Write a check. You don't want to hear that from me, okay? But what you do want to hear is, before we don't pay overtime, you want to get an explanation of what our requirements are under the law so that we comply, okay? So that's my very, very long-winded answer to Elizabeth's question, but you were spot on, okay?
I appreciate that.
So let's talk about some of the important laws that are impacting the COVID workplace. The first one I want to talk about is the Families First Coronavirus Response Act. The Families First Coronavirus Response Act was passed in March. It went into effect April 1st, and it sunsets, presently it sunsets December 31st, although it could get extended. Within the FFCRA are kind of two sub-laws: the Emergency Paid Sick Leave Act and the Expanded Family Medical Leave Act. The FFCRA applies to any employer with fewer than 500 employees, okay? So you all fall within the FFCRA. Now, I'm going to get a little more detailed as to employers with 50 or less, which I think you all are. But let me just explain generally what the FFCRA is. The Emergency Paid Sick Leave Act entitles employees up to 80 hours of paid sick leave, either at full pay or 2/3 pay, for various reasons. One of the reasons that they could get full pay is if they're subject to a federal, state, or local quarantine order or isolation related to COVID. For example, let's say the business, and this was more of an issue back in April and May when states were in like phase 1 or phase 2. Now most states are in like phase 4 or like 4.5, Indiana. But if an employee is quarantined from going to work and the employer is open, meaning there's work available to the employee, but they can't go because of a quarantine, then they're entitled to up to 80 hours of paid sick leave. But where people got confused initially was if a business shut down, let's say a barbershop in Illinois, okay? And in Illinois, barbershops were shut down from like March through sometime in May. The barbershop wasn't open. There was no work available. So if you were a barber not working during that time, you could not get emergency paid sick leave because there was no work available, okay? So it's not likely that we're going to have a quarantine issue at this point entitling an employee to paid sick leave. But if there is such a scenario, that is full pay for up to 80 hours, okay? The second qualifying reason under the Emergency Paid Sick Leave Act is if the employee has been advised by a healthcare provider to self-quarantine related to COVID, okay? So here's how this scenario could play out, a couple different ways. An employee's spouse or partner or kid or someone they live with or a friend they came in close contact with has symptoms or tested positive for COVID. Therefore, the employee is told by their doctor to quarantine, okay? So if they've been told by their healthcare provider to quarantine, they get up to 80 hours at full pay, okay? If the employee is experiencing COVID-related symptoms and seeking a medical diagnosis, they get up to 80 hours of full pay. Now, here's the thing. If I wake up today with symptoms of COVID and I never seek to go to a doctor and I don't try to get a test, I just want to wait it out, kind of tough it out, see if I improve, that time off does not entitle me to full pay under the Emergency Paid Sick Leave Act. It has to be in conjunction with seeking a medical diagnosis, okay? So I just gave you the first 3 EPSL, Emergency Paid Sick Leave Act scenarios that entitle an employee to full pay up to 80 hours. There are 2 other scenarios where an employee is entitled to 80 hours paid sick leave, but at 2/3 pay, okay? Those are the following. The employee is caring for an individual who is either subject to quarantine means they're not allowed to go to work or leave the house, and they need to be cared for. Or they're self-quarantining because a doctor told them to. So in that situation, one of our employees could be entitled to 2/3. The reason why it's 2/3 and not full pay is the theory is, well, you're being indirectly impacted by COVID because you have to care for someone. It's not like you have COVID or you've been told to self-quarantine. So that's 2/3 pay. The other qualifying reason for 2/3 pay under the Emergency Paid Sick Leave Act, and this is a real biggie, is that if the employee must care for a child whose school or place of care is closed due to COVID-related reasons, okay? So back in March, this was a big deal because schools were closed and it went to e-learning. And it's going to become a big deal in just a week or two when schools start up again, because a lot of schools, I mean, my school district is starting off the year e-learning. If your kid is e-learning and you need to be home with them, that may entitle you to 2/3 pay, up to 80 hours. Now, there's also extended family medical leave related to the school closing. I'll get to that in a minute. But there's a lot of nuances and intricacies and caveats to whether you get the full pay. It's only if an employee cannot work because the school is closed. They need to be home with their kids. So for example, in a manufacturing environment, which doesn't apply to this group, but in a manufacturing environment where an employee is in the plant and they operate a machine, they cannot telework, okay? They have to be at their machine in order to do the work. So in that case, if they said, look, my kids are home e-learning, I have to be home with them, and there's no other suitable adult in the house to watch the kids or be home with them, then they would be entitled to the 80 hours at 2/3 pay to be with the kid. Now, for an office type employee whose work is primarily phone and computer based, if they can telework and they can telework at home even while their kids are at home, then they are not entitled to emergency paid sick leave under that scenario because they can telework, okay? Now, like for example, let's take my household. I have a rising second grader and a rising seventh grader. I cannot believe I'm gonna have a teenager in less than a month. Anyway, so my kids were home they were home in the spring, and they're going to be home in the fall. But also keeping in mind, I'm married and my wife is home too. So we have a lot of good coverage in our house. But the reality is my job is such that I just need a computer and a phone. So I can telework, and I've been working at home almost exclusively since March. So under the EPSL, I would not be able to get emergency paid sick leave just because I'm at home and my kids are at home, nor would I want it because I'm working a full, robust schedule. In fact, in many ways, I'm working more than usual these days, okay? Just doing it from home, and I'm wearing t-shirts and shorts usually. Again, I put the nice collar on for you guys. So that's that scenario. Now, here's an interesting one I've gotten. The employee is an office type employee. All they need is a phone and a computer. They're at home with their kids. And the employer takes the position, well, look, we have telework available for you, so you wouldn't get EPSL. But what the employee says is, yeah, but you never met my kids. They're a hot mess, and they need lots of help doing e-learning, and although I'm kind of trying to be funny saying that, I want to be serious in that there are kids who might have, you know, certain situations where they're not able to be the self-starters that maybe other kids are. They need more hands-on help. So I am not trying to make light of that at all.
So Brian,
yeah.
A common scenario, more common up in the north side because of people that I know, they are parents of kids with special needs. Well, and you know, the whole thing with 80 hours is problematic by itself, and we're not going to address the deficiencies in leadership and law making, but for those people, they are going to be very much hampered in caring and overseeing and stewarding their kids through any kind of e-learning.
Yeah.
And so that's a very difficult scenario. How do you handle that?
Well, okay, good question, and that leads into it's perhaps I'm not setting this up the right way, but you get up to 80 hours for being home with your kid, but there are also, I mentioned this Expanded Family Medical Leave Act I'm going to get into, that gives you an extra 10 weeks of leave time, also at 2/3 pay. So let me go into that. The Expanded Family Medical Leave Act is only if you have to stay home with your kid because their school or place of childcare is closed related to COVID, okay? The way it works is, it's really quirky. The Department of Labor wrote these laws in a confusing way. The first 2 weeks of the Expanded Family Medical Leave are technically unpaid, okay? The next 10 weeks of the 12 are paid at 2/3. However, under the Emergency Paid Sick Leave Act, that you can apply 80 hours of paid time at 2/3 towards that 2-week unpaid period. So really, to make it easy, just assume the whole 12 weeks, if you qualify, is paid at 2/3, okay? There's some other intricacies to it, but I don't think we have to get into the weeds that much. But a parent gets 2/3, you get up to 12 weeks to be home if the school's closed. Now, let's keep in mind a couple things. Under the Emergency Paid Sick Leave, an employee is entitled to that 80 hours on day one, even if they've only been an employee for 5 days. To be eligible for the Expanded Family Medical Leave, to get that 12 weeks, you have to be employed for at least 30 days, okay? And the Expanded Family Medical Leave Act is in conjunction with the regular family medical leave. Regular family medical leave applies to employers with 50 or more employees, okay? If you don't have 50 employees, you don't have to provide normal family medical leave, okay? But here, regardless of your size, even if you're under 50, which you all are, it sounds like, you get emergency family medical leave, okay? Now, it gets really confusing. If you were under 50 employees and you could show that paying an employee 2/3 of their pay to be at home for 12 weeks and not do work would jeopardize the economic viability of the business, then you could deny that leave, okay? Now, there's no precedent on what it takes to make a convincing argument that you wouldn't be able to sustain the business if you paid that leave, because this is also new. There's no cases on it. But for employees employers rather under 50 employers, you have that option. Now, let me talk about, you've heard me say paid leave at full pay, at 2/3 pay. Let me talk about what that paid leave really is. I'm not an accountant, but I married one, so that was smart of me. Paid sick leave is this: you get a dollar for dollar tax credit. So and what the way that works is the dollar for dollar tax credit you pay out to employees who get either EPSL or EFMLA leave. It comes out of, you get to deduct it from your payroll tax, okay? So you're just, whatever you're paying out, if it's, just making up a number, like $2,000, that'll come off your payroll tax. So the theory is you're kind of getting that money back on the front end anyway by not having to pay it. Also, I should mention to you that the money you have to pay for is subject to certain caps. And I'm looking at something here. For a full-time employee, the 80-hour, the pay is subject to either a cap of $511 daily or $5,110 total. For a part-time employee, the cap is $200 daily or $2,000 total, okay? So there are even caps on what you have to pay someone for each day they're out, okay? So, I mean, that's a primer on the Families First Coronavirus Response Act. And I mean, I could literally speak for hours on that. Mercifully, I won't. But does anyone have any questions about what I've said? Or I'm sure many of you have read about this, or maybe even had to apply it already in your business. Any questions about the FFCRA? Okay, so let's move on to another big issue, and that is, how does COVID-19 interplay with the Americans with Disabilities Act, okay? The Americans with Disabilities Act applies to employers with 15 or more employees. However, in Illinois, there is a parallel, and it's essentially the exact same statute, which applies to any employer who has at least one employee, okay? Under the Americans with Disabilities Act, if an employee has a disability, and a disability is defined as a physical or mental condition that substantially interferes with a major life activity, if they have a disability and they need a workplace accommodation, it is our obligation as an employer to engage in what's called the interactive process to determine what, if any, accommodation we can provide. Whether it's during the COVID era or any other part of my 21-year career, I have spent so much time advising clients on ADA issues. It's a really big deal, okay? So in the COVID era, businesses now possess more latitude in terms of the types of questions they can use to screen employees. Typically, we really can't ask employees questions about their health unless they make it an issue. Now with COVID, we can ask about symptoms of COVID-19, and they're on the the CDC website, like cough, shortness of breath, fever, and there's other typical symptoms of COVID. So every day, if someone's coming on site, we could say, hey, do you go through a checklist? Do you have a cough? Do you have a fever? Do you have shortness of breath? And whatever the rest of them are, okay? We can also ask questions regarding potential contact with infected or suspected infected persons. Does anyone in your home have COVID? Does anyone in your home have symptoms? Okay, because the idea is we don't want people on site if there's any risk that they could have COVID. We can ask about recent travel, including travel for personal reasons. There's not a lot of work travel going on. There's not a lot of personal travel going on, but usually if someone wants to go somewhere, that's their right. We have no right to ask them where they went. But now we can certainly say, hey, look, where'd you go on vacation? Did you go overseas? Did you go to a hot spot? And if they go to a hot spot, then we could consider whether we want them to quarantine, okay? Employers also under the ADA, which they were never permitted to do before COVID, we can conduct temperature screening each day. So if an employer invests in a thermometer, usually it's kind of like the little trigger gun, and you point it at someone's face, or you could point it at the wrist. You could take someone's temperature, okay? And if they have above 100.3. If they have above 100.3, then we could send them home. I hope you guys can't hear my dogs. They're kind of making an appearance in the background here, even though my door's shut.
Brian, can I ask a quick question? As you're going through the scenarios, one that's come up recently that I heard, it's interesting because it can apply to a number of different scenarios. This one is where the employer says, if you can't wear a mask because of and you have a medical exception around that, how does that impact the other workers, whether they're teachers or, coworkers?
Okay, great question. And I was going to get to some more specific accommodations examples, but let me address it. Where an employer is certain, I recommend it. I think an employer should require cloth masks be used at the workplace. If an employee has a medical, or I've even seen some cases where they have some sort of religious objection to wearing the mask, then the employer must sit down with them and listen. Well, why can't you wear a mask? Maybe they have some sort of breathing condition where the mask, asthma or some pulmonary thing, and the mask impacts them, okay? So what the employer should do is think about, well, what can we do to enable this person to work but not have to wear a mask if there's anything? It could be something like a face shield, okay? It could be implementing plexiglass between their workstation and someone else's, okay? But I would caution any employer against saying, look, no mask, no job, okay? That's an invitation for a potential lawsuit. We have to, now just because they say, I don't want to wear a mask and I don't want any prophylactic measures put on me, they're not entitled to their exact chosen accommodation or the best accommodation. They're only entitled to a reasonable accommodation, okay? So in that case, we'd have to think about other ways of protecting our other workers from that person's droplets if they can't wear a mask. And if we make a determination that we can't protect them in any other way, then we could take the position, your request to not wear a mask is a safety issue and or presents an undue hardship on the employer, and then we may be able to reject it, okay? So it's a good question you ask, and the answer could be could go a few different ways depending on the circumstances. But your takeaway should be, we can't just reject it out of hand. We gotta engage in the interactive process and see what we can do to provide alternatives. Okay. Any other questions related to the mask? Okay. So let's just talk about the duty to accommodate in general, because we may have a duty to accommodate physical or mental conditions that could be exacerbated by COVID, including less obvious ones, such as an employee they could have OCD, they could have anxiety. It could be early term pregnancy where they're not like showing. We don't even know that they're pregnant. So if they say, I have a condition which is especially susceptible to COVID complications, and I'm getting this question from clients all the time. What we need to do, and what I do for clients, is I drafted a special kind of narrowly tailored COVID-related medical questionnaire. So what we would want to do in that situation is we would want to say, okay, we're certainly open to discussing this with you. We want to work this out. We need information. So we would have them present to their doctor a questionnaire. What is this? And the questions are, what is your diagnosis relative to this employee? How long will it last? What type of accommodations do they need? Can they perform the essential functions of the job with or without a reasonable accommodation? So, and how long will they need it? Different things like that. So then what we're doing is we're making a determination on the request for accommodation with information and knowledge. We always want to act with information or knowledge for a variety of reasons. One is, well, it's just the right thing to do. Why make a decision without the facts? 2, it's fair. And 3, it's legally compliant, okay? We don't want to say no just for the sake of saying no. I will tell you, I've had clients get, whether it's related to COVID or just normal accommodation requests, they get the most ridiculous requests for reasonable accommodation. And when we hear it, we're like, oh, come on, really? But we still have to issue the questionnaire and get information and then make an informed decision.
So you've addressed the part about the specific requestor, but what about the rest of the folks that are having somebody who has, requested this exception? Mm-hmm. And what obligation do you have as an employer to ensure their safety and not put them at risk? And what if something does happen? I mean, again, it's very difficult to show traceability, but if a number of people get sick, I mean, do you open yourself up for liability?
Potentially, yes. It's an excellent question. So if we can show, look, if the employee presents and says, I can't wear a mask because I have some sort of medical reason, then, and if we can put in other safety measures, like I said, like plexiglass, or maybe isolate this employee so they're not exposed within 6 feet of other people for like 10 or more minutes at a time, then we need to do that. If we think we cannot keep a safe environment in granting this employee's request not to wear a mask, then we have to deny it. But I will tell you, and this is somewhat of a gray area, we can't take the position, well, look, we can put safety measures in place, but other people are still going to be really upset about this. We can't deny an accommodation for that reason, okay? We may lose in court on that one. Now we could explain, look, you can't get into details, of course, but you could say we have employees who, if you're an employee with a medical condition, we accommodate those. And if it appears that we're accommodating someone with a medical condition, that does not mean that we're compromising the group's health, okay? Because we're putting in place other protocols like plexiglass, certain distancing requirements, etc. Or maybe in that situation, if they can't wear a mask, but they can telework, we say, look, we understand, but you're welcome to do your work from your kitchen. We don't mind, okay? Subject to you performing well and being managed, et cetera. So there's not a one size fits all kind of answer to your question, Jeffrey, but am I getting closer to addressing your question?
I think you addressed it as best you can, Brian, under the circumstances.
Yeah.
I think the real challenge is going to be when you start to see how these exceptions manifest themselves and how the law interprets exposure and responsibility. We're in new territory, let's face it.
We are in new territory, and it's a good opportunity for me to say that a lot of these COVID-related issues that I opine on and I advise clients on, there's no precedent. So normally, I mean, a lot of what I do, I've been doing it so long, I kind of know off the top of my head, but this is all new. And when I don't know something, I do legal research. I go, what do the cases say about this? There's no legal research to be done on these COVID type issues because it's only been around since like April.
Well, what about other countries? Because they've had pandemics and diseases in other countries. We've had, this is our fourth pandemic in the last 20 years. Mm-hmm. Okay, so it's not like this is new. We did go through a number of planning and protocol when we had, swine flu and bird flu and preparation to your earlier part of the conversation. So I think there's been some law around that. I think the nuance we're talking about, of course, is a bit more unusual. I'm not even clear if they had any kind of protocols back in the turn of the century when they had the Spanish flu, but I do know that there were issues and pushback around wearing masks then. So anything that draw upon there?
Well, the Spanish flu was a little bit before my time. So I really can't opine on that at all. And I know that the ADA was not on the books back then. Now, interestingly, though, in 2009, the EEOC, which is the Equal Employment Opportunity Commission, they're the federal agency which enforces the Americans with Disabilities Act. And that agency comes up with different interpreting rules and regulations related to that law and many others. They issued in 2009 a pandemic preparedness set of guidelines related to H1N1. And really all it did was it gave employers more latitude to ask questions, personal questions related to health that they wouldn't ordinarily be permitted to ask. Now the EEOC, since COVID, has given employers more latitude, as I said. We can do temperature screens and we can ask more probing questions about the families. But really, we haven't learned much from the past about how to handle COVID, okay? And even like the Families First Coronavirus Response Act that I told you about, it was funny, when it first came out, I was sending out e-blasts to all my clients, explaining it. And then 10 minutes or less later, I'm getting calls or emails with very specific questions. And I'm like, I was honest. How the heck do I know? It just came out yesterday. I'm reporting on it. And I can only give you my best sense of what to do. But the bottom line is with reasonable accommodations, here's some guiding principles. I think we should be very flexible, always participate in the interactive process. You can only refuse to request an accommodation if it presents a safety issue or an undue hardship. And these accommodation requests, whether they're COVID related or just normal disability related, they're very, very fact intensive, okay? We really got to dive into the facts. So any questions on that?
This is Michelle. I have a question. So what if you have we have online programming, and we also we're talking about moving on site. We have somebody who's going to get a letter from a doctor saying they're immunosuppressed and, can't work.
Mm-hmm.
So they get to work online 100%. If we have to put them in every program online to keep them full-time versus everybody else having to come on site.
Potentially. I mean, the starting point is, in that scenario, well, are they immunocompromised? Okay, let's assume the answer is yes. There's no dispute over that. Then
is no dispute mean the doctor gives you a note?
Yeah, well, yeah, and we issue a questionnaire with some targeted questions, and yeah, maybe they are a fairly recent cancer survivor, or they're currently being treated for cancer. They're immunocompromised, okay? So under that scenario, the question is, can they perform the essential functions of their job with or without a reasonable accommodation? If they don't need an accommodation, well, there's no issue. Just even though they're immunocompromised, they don't need an accommodation. If they need a reasonable accommodation, and there is one that permits them to perform the essential functions of the job, as an employer, we'd be hard-pressed to deny it. So to your point, Michelle, if the employee can work remotely and work remotely effectively. Now, we don't have to compromise our standard of excellence. They have to be a self-starter. They have to be productive. They have to be able to communicate effectively remotely. Under your scenario, I know you said we have to put them in all 100 platforms or whatever. I mean, I don't know what that entails, but just generally, it seems like this person can do work remotely. Or is there a specific set of facts you want to bring to light that pushes?
No, they're already doing things remotely. So,
how are they doing at their job? Are they performing?
Can I not comment on that? That's a different question. If somebody's not performing their job, it has nothing to do with the ADA, right?
Mostly, yes, I agree with that.
So, my thing is, do you have to say other people have to have more risk by coming on site to do their programming, but this person gets to do all the online programming because they have this problem?
Well, this person in isolation, if they provide medical backup for their immunocompromised condition, and it's a job that can be worked remotely and they're doing a good job doing it, you need to let them work remotely. You'd have a hard time winning that case, okay?
Well, I'm not saying not have them work remotely. I'm saying they get to do all their work remotely, and that means other people have to come on site with a higher risk.
But so here's, okay, and this kind of leads into another thing I was going to say later in the presentation. I know we're getting ahead of ourselves on time here, but although I'm in no rush. If an employee, for an employee who's not immunocompromised, and they say, look, I just don't want to be at work because they have a generalized fear of being out in the world during COVID. And you know what? I'm one of those, I got a generalized fear, I admit it. A generalized fear alone is not enough to go to work, to refuse to go to work, okay? So, I mean, we really can't say, well, the other people are coming to work and they're afraid, you should be too, because this person isn't just not coming to work because they're afraid, they have a medical condition. If other people have medical conditions, then we'd have to consider telework for them too, unless telework is not a viable option, then we can't accommodate the request, okay? And Michelle, that kind of leads into a bigger picture issue. I believe the workplace has changed forever, okay? I will tell you, I mean, I have never worked from home in my life. for an extended period of time. I'm always working, if it's 9 o'clock, I got a phone call to make, I'll jump on my computer, but I don't typically spend a lot of time working from home, because, I'm home, I want to be with my family, especially since my office is only a 7-minute drive from my house. But I really can't see myself ever doing Monday through Friday, all day, every day at my office. I just don't need to. So I think that the workplace is changing. I think employers who have had good experiences with employees working remotely, I think there's going to be more of that. It's also a way to cut overhead and save on money because you might have less office space. I know a lot of like downtown law firms, what they're going to do now is they're going to go to like suburban pods. So if you have your West suburban attorneys, maybe you'll get an office in like a little satellite office in like Hinsdale or Downers Grove or something. And if you have your North suburban lawyers, maybe you'll be, like Northbrook or something like that. Everyone can kind of go to Easy Drive. So I just think, Michelle, that in addition to the narrow ADA component of this talk on telework, be prepared for long-term questions about working from home.
Yeah,
Telework,
our problem is our population. Some of our population, we work with adults with disabilities, and some of those people need to be on site. They can't do Zoom or remote or whatever. Online learning just doesn't work for them. And that doesn't mean you endanger people, but as we move towards that, it's very hard to they have needs, psychological needs and disability related needs that mean they have to be in person. So it gets complicated.
Yeah. So I don't profess to fully understand your business offerings, but so your employees are teachers of students with certain disabilities?
Yes, they present programming. So yes.
Okay. So, and it sounds like what you're saying is, look, I understand, the need for telework, but it just may not work with our particular student population. Is that kind of right?
Not with all of them. That's
okay.
True. So that's why we're going to the hybrid model. I mean,
Okay.
schools are doing it for, safety reasons. We are too. But
look, if it can be done safely, you would want to communicate that to the teacher. Look, we understand you're immunocompromised. Here are all the safeguards that we put in place. And maybe you should always try to carve out a middle ground in these accommodation request situations. But look, if you take the position, it has to be done in person. And you say to the teacher, well, then, I can't keep you employed. It's a tough one, okay? Because a lot of schools are going to e-learning right now. There's not, in the ones that are saying they're going to open in person, I think they might switch before they actually open in person, and B, all it takes is one outbreak or case to shut it down anyway. So I would just caution you, everything's fact specific, but I think you gotta be nimble and accord some latitude for work from home arrangements.
thanks.
Okay. All right.
Yeah. I just want to say, I know the world of special needs, I know we have an IEP in our household, and I know it's tricky. It's one of those things where a lot of families, a lot of people are really balancing that, needing to be in person and what kind of accommodations, be they schools or adults, and also knowing that, we've got health concerns on the other end of that as well. So yeah, thank you, Michelle, for presenting your example for all of us to look at as a complicated case. And I'm sure many of us on this call have some version of a complicated case that we're looking at.
Sure. Yeah, and the rest of what I was going to say are just general comments about OSHA and workers' comp. We don't need to get into those. I can summarize those, but with this. You gotta maintain a safe workplace for your people. Might deal with special cleaning. It could be reformatting the work environment with certain one-way aisles, plexiglass, staggered scheduling and shifts, stuff like that. So look, we all want to be safe. you know, you want to be safe and your people want to be safe. So that's the bottom line. So I'll mercifully shut up.
This
Brian,
has been great, Brian. Thank you so much.
yeah, I just want to thank you so much. You know, I said before everyone got on how excited I was to have your expertise here. There's no way that me or anyone who's on my side of this field could have anywhere near the information that you've presented, which I know is like a tip of the iceberg on this topic. And so, you know, one thing I definitely want to highlight for those of you who've been part of this conversation, if you have more questions, maybe you're interested in working with Brian to figure these things out for your organization. His contact information is here on the screen. Of course, I help nonprofits and you can contact me. But with that, I do want to just turn back one more time for people to ask any last questions for Brian.
This is Michelle. I just wanted to say thank you. It was very informative.
Oh, you're welcome. Thanks. You guys were a great group. I really appreciate it.
Thank you so much. Thank you, Brian. Thank you, everyone, for being on today. And yeah, I look forward to hearing from all of you, and have a great rest of your day.
Awesome. Talk to you guys. Bye-bye.
Take care.
Bye.